Case number 110976, State v. Marshall.
May it please the Court, Sarah Ellen Johnson of the Capitol Appellate Defender Office appears on behalf of Marquise Marshall. And Your Honor, I would like to request 5 minutes for rebuttal.
5 minutes is granted.
Thank you. The recurring theme at the pretrial hearings for Mr. Marshall, in fact, the only theme at any of the pretrial hearings, was Mr. Marshall's dissatisfaction with his trial counsel. The only motions that were filed in this case were pro se motions filed by Mr. Marshall. This was a capital murder case with a 19-year-old man facing a life sentence without the possibility of parole, and the only motions that were filed by Mr. Marshall himself.
Did he file them? They were his motions, but
Yes.
Did he write? They're pro se motions, but he didn't write them, did he?
He had difficulty writing, so he did have whatever kind of assistance. What's on the record is all the information that's out there, which is that somebody else helped him with the actual typing out of these motions.
Well, why don't you get to the heart of it? Where is there justifiable dissatisfaction with his, either in his motion or what was before the court with Mr. Evans?
Well, I would argue that the heart of it is actually a step before that, and that the district court failed completely to inquire. No questions were ever asked of Mr. Evans about any steps that were taken. It's often occurs when these motions come up that there will be an in-camera sort of hearing where the district attorney will step out for a brief moment so that the defense attorney and the client can truly hash out for the judge what the issues are. Nothing close to that occurred in this case. In the first hearing on the first motion, in fact, the district court judge basically talked Mr. Marshall into withdrawing the motion on what I would consider to be a false ground, which is that it was premature. This was a motion that had been filed in April and was discussed in May for a case that had originated in December. Mr. Marshall had been in custody for 5 months, had had counsel appointed for 5 months. There's nothing premature at that point about having a failure in a relationship with your attorney. The judge treated it more like an ineffective assistance claim, which of course there was no court performance yet to judge, but that wasn't what Mr. Marshall was complaining about. Mr. Marshall was complaining about not having any sense of effort from his defense attorney, and there was no effort by the trial court to get into that at all. Similarly, with the second motion that was filed, once again, it was more the district court judge talking Mr. Marshall into, this is the one where he said, somebody else filed this for you, and basically instructed, without actually saying it, that Mr. Marshall might be in trouble for having these motions filed on his behalf or prepared for him. And so again, Mr. Marshall was a little bit more talked down from airing his claims instead of a robust inquiry into what is it that Mr. Evans is or isn't doing, what is it that you're missing, what is it that you're concerned about. When a judge repeatedly shuts down the defendant who's making these arguments or making these claims instead of inquiring, that is the problem that we have in this case.
Are we talking about what you started by saying completely failed to inquire, or are we talking about the adequacy of the inquiry? I mean, what I'm seeing is the defendant gets, he's asked at the August 27th hearing, saying, what are these two motions about? And I mean, that seems to be the start of an inquiry. And then he responds. So, and the case law is pretty clear about what it means to fail to inquire. You get it, and then you never look over and do anything. So where are you trying to categorize what happened here?
That this was an inquiry meant to shut it down, not meant to actually explore any difficulties.
So it's an adequacy of the inquiry.
Correct.
Issue.
It's that I would say that perfunctorily asking a question with leading answers that are meant to stop the inquiry rather than get to anything substantive, that to me is not an adequate inquiry. With the first hearing in May, the district court really talked Mr. Marshall into this false idea that this was a premature motion. I have a hard time considering that a genuine inquiry when the district court seems to be guiding where the inquiry is going rather than letting the defendant himself speak. He also never asked the defense counsel for his take on things. And I believe that that would be necessary for a proper inquiry into the attorney-client relationship.
Does our review standard change if there is a complete failure to inquire versus a failure to have an adequate inquiry?
I would suggest no, because the standard of review is the same. The question is, there are some things that are inherently an abuse of discretion, and there are some things where you get to a later step where it is a more discretionary decision. A district court judge doesn't have discretion to be wrong in the law sort of argument. So it all falls within that umbrella of abuse of discretion, but it depends on what step you're at, what the discretion is that the district court judge has. And I would say that the district court really doesn't have discretion to just shut down the inquiry and not really consider the defendant's point of view and not ask the defense counsel at all to discuss what the potential communication breakdown is.
Well, we have case law that suggests that the second the district court turns over to defense counsel and says what's going on, that the defense counsel runs into problems arguing against the interests of his client.
Certainly, it's a difficult balance, and that is why you'll often see the in-camera sort of discussion where the prosecutor leaves the room, and so there can be a more candid discussion. It is a difficult position for the defense counsel to be put in at that stage. That doesn't make it incorrect for the district court to at least ask, which didn't happen here.
On the spectrum of abuse of discretion, with a per se abuse being that there was no inquiry, no back and forth, you would say we move off that pinpoint and move down the spectrum a little bit?
I would say a little bit, yes.
Okay. But and does that vary with the various hearings? The first one, I understand that you're saying it would be an abuse of discretion because he talked Marshall back out of the motion. But then after that, doesn't he, in the subsequent hearings, doesn't he ask more questions and even ask open-ended questions and say, explain to me what your complaint is? And Marshall's response generally there is, I don't know what to say.
He does. I would note that in the second hearing, there's still the sort of umbrella of, I don't even have to consider this because this is a falsely filed document because it involves the illegal practice of law. Which, with perhaps a naive 19-year-old defendant, works as sort of a leading question to, I don't really want to talk about this. Like, I could just shut you down right now. And so I think Mr. Marshall was sort of, even though he was asked open-ended questions, it was also under the guise of, shut this down, I'm already done listening. And I believe that was Mr. Marshall's position, was at that point he didn't know what he could say to get the judge to listen to him.
Even in the first motion hearing, where you talk about that it's inappropriate to talk, that it's premature, and that there can be a breakdown even in the early stages. Having explained all that, the last thing that the court does before there's a waiver is, I need to inquire of you if you desire to proceed with the motions to have Mr. Evans dismissed as your counsel. So he did that inquiry, and your client said, no, I would like to withdraw that. Are you going to withdraw those? Yes. So there was an opportunity, and opportunity to inquire, and your client chose not to.
Again, it's our position that he was led to that and
Right.
led to
I
believe that
understand
was
that's
the,
your, right,
that's
I understand.
that's our position.
Okay.
I see that I am almost out of time.
I need to ask you
Yes.
a question about the psychiatric evaluation. Are we talking about for purposes of a defense or for purposes of competency to stand trial? It appears to me there's evidence that both were needed.
That the motion that was filed doesn't clarify, so we're a little left guessing with a pro se motion, and again, there was very little effort to flush that out. Reading through this case and especially watching the interrogation videotape, or more importantly, the parts where Mr. Marshall was alone in the room, it seemed that there were some issues that should be explored there. The record has the information it has, and that's all that there is. So what the exact evaluation should have been, I'm
And
left.
defense counsel indicated to the trial judge that he didn't see a problem with competency.
Much closer to trial, yes, that was said. But again, that's all we have.
But was
Really
there
on the
any,
record.
there wasn't any discussion about a defense?
Never,
Nothing on the record.
nothing on the record.
Okay.
That what is in front of us is what it is. So it would have been nice to have had some of that fleshed out on the record, but we have what we have.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. We will also be beginning our course of the argument with the second issue before the court, which is the manner in which the court addressed the defendant's apparent request for substitute counsel. Reading of the record in this case reveals that the court addressed this issue with the defendant on 3 separate occasions, the first occurring 4 months after the defendant was arrested in response to the defendant's pro se motion that Mr. Evans was, quote, ineffective and unethical in failing to communicate with him. The court conducted a hearing on the matter and explained to the defendant, we are facing a capital murder proceeding here. It's a lot slower going. While there have been delays and a considerable amount of discovery exchange between the parties, this type of case is going to go a lot slower than, say, your Walmart shoplifting case. The court then inquired of the defendant how it was he would like to proceed, and by all indications, the defendant voluntarily withdrew that motion. The court addressed this issue a second time, approximately 3 months later, again in response to a pro se motion from the defendant, where he indicated, essentially just in bullet points, that he wanted a new attorney because they had irreconcilable differences, a breakdown in communication, a conflict of interest, and a lack of communication. Those factors were not fleshed out in any form during that motion or as a part of that motion, so the court again conducted a hearing, and he personally addressed the defendant, explained to him again, this is an extraordinary case, and probed the defendant for specifics. In order to get the relief you're seeking, I need to understand exactly what it is you're claiming. And the defendant was not able to provide any specifics other than, I don't think he's doing his best for me, and he's not communicating with my family. The court explained to him that without the specific foundation for that claim, there wasn't any relief that could be provided. And with respect to the claim regarding his family, that Mr. Evans' diligence and his duty was to the defendant and not to his family. With respect to the third instance, I think it's notable that this is something that the court did on its own accord. Shortly before trial was scheduled to commence, the court received information from Mr. Evans that in the immediately preceding 10-day period, On 4 separate occasions, the defendant had refused his visits with his attorney, had refused to even exit his cell, and had refused to try on the clothes that Mr. Evans had brought to him. The court noted for the record, I believe it is prudent to get to the foundation for this behavior and understand what it is that is making Mr. Marshall behave in the manner that he's behaving. He addressed the defendant personally again, and all the defendant could provide for him was, we don't see eye to eye, and he's not doing his best for me. The court again explained, I need to understand specifics. I need to understand what it is that's giving rise to this behavior and your assertions. Again, the defendant was not able to provide anything. The court addressed him and said, how would you like to proceed? He said, I would like to go ahead with counsel, and I intend to wear the clothes on Monday that counsel has brought for me. Counsel has, or opposing counsel has indicated in her brief that the court utterly failed in its duty. I think a fair reading of the record in this case reflects that the court undertook its duty to inquire into the issues that the defendant had presented. In order to obtain substitute counsel, a defendant has to demonstrate or allege justifiable dissatisfaction, which is a breakdown in communication and a conflict of interest or the irreconcilable differences language. That burden has not been satisfied. A fair reading of the record demonstrates that the court properly exercised its discretion in this case. Unless there are any questions from the court.
Well, what about the kind of, on the third, how did that occur? The court becomes aware that there's been a refusal of Mr. Marshall to see Mr. Evans.
It is my
How did
understanding.
that happen?
It is my understanding that the court was made aware from its record volume 8, page 5. It seems to indicate that Mr. Evans made contact with the court. The court says on page 5, Mr. Evans has advised, however, that his last 4 attempts to meet with the defendant have been fruitless, as defendant has refused to come out of his cell. Moreover, the defendant refuses to exit his cell or even try on the clothing. So it seems to indicate that maybe Mr. Evans had made contact with the court to let him know that this was transpiring. But any other, that's as much clarification as I can
What was the
provide.
purpose of then the court's summation of the evidence that Mr. Marshall would be facing? It just, in reading the summation, I've read it over several times, it does seem conclusory. It almost as if the court has reached a conclusion on the evidence, but then says, I'm not the trier of fact, the jury is. What about all that whole dialogue there?
You know, I think the court was of the opinion at some point that the defendant perhaps did not like, and I believe there was actually, and I don't have a record cite for you, I believe there was actually a comment from Mr. Evans that I have been upfront with the defendant about what he's facing as far as the strength of the evidence against him and what we're facing as a possible theory of defense. And I think the court was coming from the perspective of, I think what you're truly unhappy with, Mr. Marshall, is the reality of the situation that you're facing, and that there is only so much Mr. Evans can do for you in light of the evidence that's against you, but he is still working to the best of his ability, and he is still performing his duties in the most diligent fashion that he can. If there are no further questions from the court, we would respectfully request that the decision of the district court and the defendant's conviction be affirmed.
I want to ask you about the request for a psych eval.
Yes.
Did the trial court ever make a finding whether there was reason to believe that this defendant was competent to stand trial?
I think the provision that governs indicates that when the court becomes aware that there is some question regarding his competency, he's required to terminate the proceedings and make that inquiry. What is on the table as far as any indication in that context is the defendant's motion itself, the statements that were made while he was in the interrogation room alone, and then the inexplicable nature of the crime itself. With respect
Which
to...
would go to his defense as well as competency, would it not?
Well, it could, but that defense wasn't advanced, and we don't know why that defense wasn't advanced, and we certainly aren't in a position to speculate based on this record why that defense wasn't advanced. As far as the motion itself, the court conducted a hearing on that motion, and the defendant specifically advised or informed the court, I didn't write that motion, I don't even know what Larned is. So it's not as though the defendant was coming forward and saying, I think there are issues regarding my competency, or there are issues that need to be addressed.
We understand the facts, but what I'm trying to clarify is I don't think the court ever made a determination whether there was reason to believe, or when it comes before the court has to determine competency.
Well, and I guess then we can't divorce ourselves from the facts. I mean, you have said to me that you understand the facts, but the court didn't make that inquiry, and those facts are what drive that inquiry. On what basis was the court going to make that inquiry? And that foundation wasn't there. That pro se motion certainly doesn't provide a foundation. The statements that have been highlighted from his interrogation, where he was alone in the room, cannot be viewed in isolation. We have to look at the entirety of that investigation, where he was able to communicate effectively and coherently with the detectives. He provided appropriate responses to their questions. He asked clarifying questions of his own. He indicated, or he exhibited, an understanding of the process that he was undergoing. His communications with the court were coherent. So there isn't a factual basis here that would drive the court to make that inquiry.
So, but did the court ever make a determination of competency, ever state that I find that you're competent to stand trial?
No, because it was not asked to do so. There wasn't a situation where it was required to do so.
Any more questions?
Was the motion denied though?
Yes.
Yeah, so although he may not have used the magic words, he in effect denied the motion for a Larned eval.
He did, because there was no basis to undertake that evaluation. Because again, the defendant indicated, I didn't write this, I don't even know what Larned is. So the facts set forth in that motion that I have been to Larned and I've had mental health issues also do not have any validity or credibility when he says, I didn't write that motion and I don't even know what that is.
Any more questions?
Had he in fact been to Larned?
There is no indication that he had been. There's no indication from his criminal history that there were any offenses committed by him in the past that it would have necessitated that. There is no indication whatsoever that he either required an evaluation or had need to undergo one in the past. And I think this court said it best and it's cited in our brief in Shoptease, where it says, if the accused is capable of understanding the nature and object of the proceedings going on against him and can conduct his defense in a rational manner, he is, for the purpose of being tried, to be deemed sane, although on some other subject his mind may be deranged or unsound. So I believe that goes to the nature of the offense, doesn't necessarily drive the outcome of that analysis.
Thank you, counsel. You reserve 5 minutes for rebuttal.
Your Honor, I would waive rebuttal unless this court has any questions.
Any questions? I see none. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.